Hi everybody, in today's video I have a couple of immigration updates to share with you. The public charge rule is officially over. In addition, the House is expected to vote on 2 separate immigration bills next week. In this video, I'm going to update you on the important information that you need to know about, so make sure to stick around. Hi everybody, my name is Michael Ashoori and I'm a U.S. immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and we regularly post videos to make sure that you're up to date with the latest immigration news. So if you haven't yet subscribed to our YouTube channel, make sure to hit the subscribe button now. Also, make sure to give this video a big thumbs up so that YouTube knows to share this information with more people. So as I mentioned, in today's video, I have a couple of immigration updates to share with you. The public charge rule is officially over. In addition, the House is expected to vote on 2 separate immigration bills next week, so I'm going to share those details with you now. So let's start off by talking about the public charge rule. Earlier this week, we came to learn that the public charge rule will no longer be enforced. This is wonderful news for many people that plan to apply for their green card. And let me start off by explaining what the public charge rule is. This rule was enacted in 2019, and what it did was it allowed immigration officers to weigh various factors, such as somebody's age, their English speaking ability, their employment history, and their previous use of public benefits. And it allowed the immigration officer to weigh these different factors, determine whether they thought that the immigrant or the person that was applying for immigration benefits would potentially be a public charge, whether they would be somebody that would be relying on government benefits in the future. And if the immigration officer determined after weighing these factors that the person was likely to become a public charge, they could potentially deny that person's application for immigration benefits. So that's what the public charge rule was. So again, this rule was enacted in 2019, and once it went into effect, it faced many legal challenges. It was the subject of multiple lawsuits. And over the last few years, it was regularly getting blocked and reinstated and blocked and so on. Well, as I mentioned earlier this week, the Biden administration announced that it will no longer be enforcing the public charge rule, and USCIS issued an announcement earlier this week as well, announcing that they will no longer be enforcing the public charge rule. So take a look at my screen and we'll go through this announcement together. So take a look at my screen, and as you can see over here, this is the USCIS website, and we're on the public charge page. And it says here, USCIS is no longer applying the August 2019 public charge final rule. As a consequence, among other changes, USCIS will apply the public charge inadmissibility statute consistent with the 1999 interim field guidance. In other words, USCIS is not considering an applicant's receipt of Medicaid, except for long-term institutionalization at the government's expense, public housing, or Supplemental Nutrition Assistance Program SNAP benefits as part of the public charge inadmissibility determination. Now I want to scroll down to some important information. And it says here, applicants and petitioners should not provide information or evidence related solely to the public charge final rule. That means that applicants for adjustment of status should not submit Form I-944, Declaration of Self-Sufficiency, or any evidence or documentation required by Form I-944 when they file their Form I-485. There's additional information there as well. Now, one more important point that I want to mention. It says here, if an applicant or petitioner already provided information related solely to the public charge final rule and USCIS adjudicates the application or petition on or after March 9th, 2021, USCIS will not consider any information that relates solely to the public charge final rule, including, for example, information provided on Form I-944, evidence or documentation submitted with Form I-944, or information on the receipt of public benefits on Form I-129 Part 6. And it goes on. It says here, if you received a request for evidence or notice of intent to deny requesting information that is solely required under the public charge final rule, including but not limited to Form I-944, and your response is due on or after March 9th, 2021, you do not need to provide that information. However, you do need to respond to the aspects of the RFE or NOID that otherwise pertain to the eligibility for the immigration benefit sought. So as you can see, USCIS will no longer be enforcing the public charge rule of 2019. 2019. So what's going to happen now? As we saw from that announcement, USCIS is going to be using the 1999 standard for determining public charge, which is far less restrictive for new immigrants. So what about pending cases? What if you received an RFE that's requesting information such as the Form I-944? As you can see from the USCIS announcement, you are no longer required to submit the Form I-944 even in an RFE, assuming the deadline to respond is on or after March 9th, 2021. So this is wonderful news for thousands and thousands of people planning to apply for their green card, and it makes obtaining a green card easier for people that would otherwise face these difficulties due to public charge. So the next update that I want to share with you is that the House will likely vote on two separate immigration bills next week. The two bills are the Dream and Promise Act and the Farm Workforce Modernization Act. Now, the Dream and Promise Act seeks to offer a path to citizenship for undocumented dreamers that came to the United States as children and to certain people that are in the United States under temporary protected status. The Farm Workforce Modernization Act seeks to provide legal status for thousands of people that are working in the United States in agriculture. Now, again, the House is planning on voting on these two separate bills next week. I want to discuss why we're seeing these bills introduced in the House. It looks as if these two immigration bills are an attempt at getting some of the components of the U.S. Citizenship Act of 2021, the much larger bill, passed in a more piecemeal fashion. So we're going to closely monitor to see what happens next week and to see what happens in the coming weeks ahead in the House and Senate. So there you have it. In this video, we talked about two major updates. The first update that we talked about is that the public charge rule is officially over and done with. And the second update is that the House will likely be voting on two separate immigration bills next week. So I hope you guys found this information extremely helpful and beneficial. If you know anybody that can benefit from this information, make sure to share this video with them. We're all about empowering you with knowledge. So the more people that can watch this video that can benefit from this information, the better. As always, thank you guys so much for tuning in, and I'll see you on the next video.